Wow, guys, we're in the thick of it. The crypto SEC war is red hot right now, and the end result is still extremely unclear for almost every single actor in crypto. Ready? Let's go. Today, we are going to discuss the unsealing of the Hinman docs, the soon-to-be infamous Comment 13, other comments that conflict with the outcome of the LBRY case, what all of that may or may not mean for crypto, a former SEC insider on who they may attack next, and the SEC's wildly recalcitrant response to the court order in the Coinbase Writ of Mandamus case. If you looked at this image and understood that these current cases are just battles in the larger war where we're all in it together, or if you're finding value in these videos each weekday, please consider delegating to the army of spies. Stake pool, ticker, AOS. Here we are after years of litigation between Ripple and the SEC. We finally get something that the Ripple contingent has been looking forward to, has struggled to obtain for a long, long time. We finally got the unsealing of the Hinman emails. So despite how hard the Ripple side had to fight to get this, the interesting thing is I'm not really sure how much it moves the needle in terms of this central question. The central question is, what is a security in crypto? Which cryptocurrencies are securities? This is very embarrassing for the SEC. It makes the SEC look like it's a mess. I'm not sure how much it changes things in terms of us not really having an answer to that central question, though. So the Ripple side, they obviously produced, like, they knew this was coming and they've been waiting for a very long time for this, and they wanted to leverage the moment as well as they could. And there's a lot going on Twitter today around this moment. But here is Stuart Alderoty, the chief legal officer at Ripple, and he posts a very nice thread here going through really the high points of the unsealed Hinman documents, a lot of which are comments to his actual speech, the infamous speech. So on June 14th, 2018, Hinman gave this speech where he basically invented this magical fifth prong to Howey. We've talked about the Howey test a million times. We're not going to rehash it here. We talked about it even yesterday. So go back and listen to that one if you have no idea what the Howey test is, or this magical fifth prong. So the magical fifth prong is sufficient decentralization. Somehow, if you're sufficiently decentralized, the rest of the Howey test doesn't matter, and you magically get out of being a security. Here we see the inner workings of how that happened. And it turns out that other people in the SEC weren't really on board for this. So here's the thread. Stuart Alderoty says, it's been 5 years since Bill Hinman gave his infamous speech, and through the SEC's lawsuit against Ripple and 7 court orders, we can now finally share what happened behind the scenes through the now public emails and drafts of the speech. And a lot of the action is going to be in the comments to the speech from other people. We can now all see Hinman ignored multiple warnings that his speech contained made-up analysis, this magical fifth prong, with no basis in law, was divorced from the Howey factors, exposed regulatory gaps, and would create not just confusion, but greater confusion in the market. I think all of that is true. A refresher, Hinman is head of the SEC's Corp Fin, that's corporate finance, the corporate finance division in the SEC, gave a speech in June 2018 declaring that a token is not a security once it becomes sufficiently decentralized, the magic fifth prong. And he invented factors to consider when making a sufficiently decentralized determination. If you're not aware, this is not really how regulation is supposed to work in the US federal system. Although Hinman claimed that the speech was his personal view, he and the SEC touted it as guidance. Then SEC Chair Jay Clayton publicly pointed to it. Despite the SEC repeatedly flip-flopping on the significance of the speech in litigation, it remains on the agency's website. So this is a bad look for the SEC. It makes the SEC look like it's internally a mess and there is no unified approach for all the reasons we're about to get into. Now let's look at what senior SEC officials directly said to Hinman about his speech as he was drafting it. Head of Trading and Markets, T&M, said, because the list of factors is so extensive and appears to include things that go beyond the typical Howey analysis, we have concerns this might lead to greater confusion on what is a security. Hinman ignored those concerns. T&M, that's Trading and Markets again, Trading and Markets directly asked Hinman to tie his newly invented factors more closely and explicitly to the Howey analysis. Again, Hinman ignored the suggestion. I think anybody who's ever been involved in drafts of a document with commenters, commenters to the draft, you can understand a lot of times the original author of the draft just kind of ignores comments. So then we have the Office of General Counsel and Trading and Markets calling a certain factor legally irrelevant. Has this person or group retained a stake or other interest in the digital asset such that it would be motivated to expend efforts to cause an increase in value in the digital asset? Hinman kept it. So they're calling this factor legally irrelevant. And if we look here at this particular comment, it says, why is this factor relevant and how would it be applied? So you've got a problem. It's unclear here whether that was the Office of General Counsel or Trading and Markets, but one of the internal SEC commenters on this draft is asking the question, why is this even relevant? This is very important because this was something that the SEC argued successfully in a case we've already seen resolved. We're going to cover that later on in this video. So then Trading and Markets and the Office of General Counsel noted Hinman skipped over the threshold jurisdictional question of whether a digital asset meets the legal standards of a security. He jumped to asking whether SEC oversight could, in Hinman's view, be beneficial. Hinman ignored this regulatory gap. This is the very soon-to-be infamous comment 13. I think this is the most important thing unsealed in all of the Hinman documents. So if we look at this more closely, they say, the commenter says, while we agree that a central purpose of the Securities Act is to address an information asymmetry, so they're saying, hey, the whole point of the Securities Act is that the promoters of a security have a lot of information that the buyers of the security might not. Let's reduce that information asymmetry. Let's make sure the buyers have all of the information, all the important information, at least, that the promoters have. Then they go on to say, I think we worry that it does not follow that there is no longer an asymmetry once a network becomes decentralized. So they're saying their conceptual approach is information asymmetry and mitigating that asymmetry. And they're saying it doesn't logically follow that if a network is decentralized, there is no asymmetry. So obviously, this is not the approach that someone like Hinman or somebody who likes the decentralization prong, the magical decentralization prong, that's not really their approach. They're not saying that, I don't know of anyone saying that the decentralization somehow impacts the information asymmetry. I think really what they're saying is that there's no promoter. There's no central promoter, in that case. So they go on. There likely are still people who have far more information. Buterin likely has far more information than retail purchasers of Ether. In fact, disclosure is likely to still be important to purchasers, and disclosure could help address the information asymmetry that is likely to continue to persist for some time after decentralization. But the bigger point is that it's no longer an investment contract once there are no efforts of others to point to. Plus, without a group in control, there's no one to hold responsible for providing disclosure. And here they're getting to what it really is. They're saying, hey, there's this information asymmetry thing. We don't think the decentralization impacts that. But the bigger point is that if there's no central party, it's no longer an investment contract once there are no efforts of others to point to. And they say that's the bigger point. The bigger point is that it's no longer an investment contract once there are no efforts of others to point to. And that's what the Howey test really is. It determines what's an investment contract because an investment contract is part of that laundry list of securities. It's one of the items in the laundry list of securities in the 33 Act. They say, plus, without a group in control, there's no one to hold responsible for providing the disclosure. This is what people are really after with that fifth magical prong. The fact that tokens are Tokens on a sufficiently decentralized network are no longer securities and no longer are required to register with all the benefits to investors of registrations seems to point out what might be considered the regulatory gap that exists in this space. In other words, this speech acknowledges that there is an other category. It's not a security because there's no controlling group, at least in the Howey sense. Yet, like many other things, medication, credit cards, there may be a need for regulation to protect purchasers. This is actually the truth of this central question. The big question in crypto for a long time, at least from a regulatory perspective, has been which cryptocurrencies are securities? That's the wrong question. And this comment actually from the SEC, from someone internal to the SEC, either in trading and markets or the Office of General Counsel, is actually speaking the truth about crypto here. They're not really securities if they're decentralized. There's something else, but there's still this information asymmetry in a lot of cases. You could be completely decentralized and still have someone, they point to the example of Vitalik Buterin. I think they probably wanted to use EG as opposed to IE here. I think they're saying, for example, instead of that is, maybe they did mean that is. Maybe they're only thinking of Ethereum here, but I think it's more of an example to me. But you can have these examples of a totally decentralized cryptocurrency where it meets this bigger point they describe. It's no longer an investment contract because there are no efforts of others to point to. There's no central party. And without a group in control, there's no one to be held responsible for providing the disclosure, but you still need disclosure. And that's why I've always said what we really need is another regulatory framework. We need something else outside of securities. Cryptocurrencies that are decentralized aren't really securities in any sense that would have made sense to the court that wrote the Howey opinion. The court that created the Howey test, they were doing that, almost a century ago. They weren't even imagining the internet or crypto or digital assets or cryptocurrencies. It was so long ago. It doesn't make any sense. And decentralized cryptocurrencies just don't really meet the test if there's no, like they said here, efforts of others to point to. So we just need something else. We need a brand new regulatory regime made, custom tailored for cryptocurrencies. So I think this is actually the real reason why the SEC didn't want the Hinman documents to get unsealed. So everybody thought it was this, what's covered in the rest of this thread, the whole sequence of events that have been referred to as ETHgate. And that's, all of this stuff, Hinman writing that he didn't see a need to regulate ETH as a security and would call Vitalik Buterin later that week to confirm our understanding. The Office of General Counsel expressing its reservations about building a statement, including a statement directly about Ether in the speech, because it would make it difficult for the agency to take a different position on Ethereum in the future. Ethereum remained as a cited example in the speech. So I think everybody was very focused on the ETHgate stuff, but I think this comment 13 was really the big problem. This was why the SEC didn't want this to get unsealed. Yeah, the Ethereum stuff is all messy and it doesn't look good. It's embarrassing for the SEC, I'm sure. But this comment 13, it tells the truth about what should happen with crypto. That's someone either in trading markets or the Office of General Counsel, and I'm sure we can figure out who made that actual comment, but that's the real problem because they're saying, hey, these aren't securities, but we still have this information asymmetry problem. They're this other thing. In fact, they specifically explicitly say there is an other category. It's not a security because there's no controlling group, at least in the Howey sense, yet like many other things, there may be a need for regulation to protect purchasers. That's exactly the case with crypto. There's a lot of need to protect buyers of crypto assets. And there are a lot of, bad things that happen in crypto because there's no regulation, but they're just not securities under, any kind of like common sense reading of the Howey test. Granted, the Howey test is extremely broad, and it won't shock me at all if the judges in these relevant cases come to exactly the decision we don't want them to. They just decide, oh, this is too messy. Let's just call them securities. Let's fit them into the existing framework. Let's just shove this, square peg in this round hole or round peg in this square hole, whichever one is harder. And that could happen. That could easily happen because that would be much tidier than saying, hey, SEC, these actually aren't securities. Congress, you need to actually come up with a new regulatory framework because these things are securities, but we need some protection here. Much tidier just to shove that wrong shaped peg into that hole and say these are securities just so they're regulated somehow. So the courts could come to completely the wrong decision, but this comment 13 actually lays out the truth. Paul Graywall, top legal guy at Coinbase, is very smart, and he seems to have come to the same conclusion. He says the regulatory gap, proof from the Hinman emails of what we've been saying to the Third Circuit, to Congress, and to the SEC itself, that the security laws are incomplete when it comes to digital assets, that security laws aren't meant to rule over all digital assets, and that many digital assets are not securities. I would have put it differently. I wouldn't say that they are incomplete because that implies we should just complete them and push crypto under the SEC. We should say that security laws do not encompass crypto. Security laws do not cover crypto. We need a brand new framework, a brand new set of laws. Here's the problem, though. Here's the problem that all of crypto finds itself in. This is just a comment from some guy who's an employee of the SEC. That's what the SEC is going to say. They're going to say, hey, look, we're a large organization and we have a lot of employees. And occasionally, just like in any organization, some of our employees will have a different opinion than our actual official position. That's just sort of chalked up to the nature of human beings. If you get a bunch of human beings together, even if they're all, supposed to be, on the same team, working toward the goals of the organization, they might personally hold different opinions. So the SEC is going to say that this comment is not authoritative or dispositive in any way. Realistically, though, if this is from the Office of the General Counsel, and it's still unclear to me whether this is from Trading and Markets or the Office of the General Counsel, but if this is from the Office of the General Counsel, that means that the part of the SEC that's kind of responsible for legal interpretation is of the opinion that the crypto scene is right. The SEC is not the right organization to be, regulating crypto, or at least currently, because the SEC is sort of in charge of regulating securities. They're kind of saying that, they're actually saying, at least, maybe that's too far. We can say they are characterizing Hinman's speech as acknowledging that there is another category that probably needs to be regulated, but is not actually a security because there's no controlling group. So realistically, this is very embarrassing for the SEC. It shows that even people within the SEC don't agree. But as a legal matter, the SEC is going to argue this is just one employee having a different opinion from them and expressing it in a comment to a draft of a speech. So remember when I said that a piece of this relates to a case that's actually already been resolved? That was this piece where Hinman lays out this factor. Has this person or group retained a stake or other interest in the digital asset such that it would be motivated to expend efforts to cause an increase in value in the digital asset? And Hinman kept it in, but he got comments like, why is this factor relevant and how would it be applied? So Stuart Alderodi characterizes that as Office of General Counsel and Trading and Markets, calling this factor legally irrelevant. So this actually did come up in the LBRY case. So LBRY quotes that tweet and says, in SEC versus LBRY, SEC successfully argued that holdings alone, even absent any public statements, make token sales a security. And they want you to look at this quote from the ruling. So the judge actually accepted this argument and included it as part of the ruling. Meanwhile, the SEC's Office of General Counsel said privately this factor was legally irrelevant. So here they say the problem for LBRY is not just that a reasonable purchaser of LBC would understand that the tokens being offered represented investment opportunities, even if LBRY never said a word about it. It is that by retaining hundreds of millions of LBC for itself, LBRY also signaled that it was motivated to work tirelessly to improve the value of its blockchain for itself and any LBC purchasers. We covered the LBRY case in detail when it came out. This is very unfortunate and would definitely be a very bitter pill for LBRY to swallow. Seeing this come out now, when even they're saying it was the Office of General Counsel who made that comment. I'm still unclear to me exactly which of those groups, Trading and Markets or OGC, made that comment. But I don't blame LBRY here for saying this is a clown world where the Office of the General Counsel of the SEC may have said this, and then the SEC argues this successfully, and it's included in the ruling later in the LBRY case. Does this seem extremely unfair to LBRY? Yes, of course it does. But again, the SEC is just going to say, hey, this is somebody on our legal team expressing an opinion in a draft. This is not dispositive in any way. And, there is something to that. I mean, just because a member of your legal team has an opinion that's sort of adverse to your litigation goals, that that doesn't necessarily doom you in court. I mean, this is kind of a weird situation. Normally, you don't get to find out anything that the opposing side's attorney may have told them about anything. It's not something that happens, but because this is the SEC and there were all these issues with the Hinman speech, Ripple was able to get a hold of this. So it's kind of a weird thing to be able to see this in a case period. But, your own attorneys can have opinions that don't necessarily help you, and it doesn't necessarily doom you in court. So here's something interesting though. Here is a former insider at the SEC. Right here it says SEC Gov Enforcement. That's a former role, and this person was interviewed on this social media channel. I guess it's a podcast. Hard to say what this is, but it's some kind of interview on this channel. And she was kind of explaining what was going on with the SEC and crypto right now. She talks about how the SEC, in her day, the SEC was going after ICOs. Now they seem to be going after crypto intermediaries. And her guess about what was going to happen next is really the interesting part. She guessed, as you can see here from this caption, that the SEC was probably going to move on to DeFi next. And this makes sense because we saw some interaction, which we covered on this channel, between the SEC and Uniswap. If you think about crypto DeFi and you're the SEC, what do you do first? First thing, as part of your sort of initial stages of investigation, you say to yourself, what is the biggest crypto DeFi platform? Uniswap, especially in those days, it would have been Uniswap. And then we saw that, certain things happened. All of a sudden, Uniswap seemed to remove synthetic assets from the Uniswap Labs version of the front end for Uniswap. There were other front ends, some of which did not remove synthetics, but the front end run by Uniswap removed synthetics from their platform. But, that we don't know exactly what was happening there. That could have been, and we know there was some interaction between US regulators and Uniswap. It was reported widely in the news and covered on this channel. We don't know exactly what the SEC was up to there. We don't know if they were just interested in synthetics or if they were just asking questions and demanding documents from Uniswap generally. And Uniswap decided to mitigate risk by getting rid of synthetics on their version of the front end. But we don't know. Maybe the SEC was just generally trying to, learn about Uniswap to prepare for going after DeFi platforms generally. So that was her guess, that DeFi is on the radar next. Finally, here's another instance of wild behavior by the SEC. So this is in the Coinbase petition for writ of Mandamus case. So basically, Coinbase is petitioning the SEC to do some rulemaking, provide some regulatory clarity for crypto. And this was a post we covered about a week ago on the channel from Paul Graywall, again, top legal guy at Coinbase. He says, earlier tonight, the Third Circuit issued a short order in Coinbase's Mandamus action. The court noted the SEC's suit against us this morning and asked the SEC whether that means the SEC has decided to deny our pending petition for rulemaking. The SEC has 7 days to respond. So this is a court order. This is not a series of court suggestions. The court is ordering the SEC to do the following. Submit a letter within 7 days addressing the following: whether the SEC has now decided to deny Coinbase's petition for rulemaking. Remember, this was after the SEC filed their complaint against Coinbase. If not, how much additional time the SEC requires to decide whether to grant or deny that petition, and why this court should not retain jurisdiction and order periodic reports as Coinbase has proposed, and or establish a deadline by which the court will rule on Coinbase's petition for writ of Mandamus if the SEC has not yet granted or denied the petition for rulemaking. You probably note the spiciness in that item number 3. So we now have a response from the SEC. And let me tell you, the SEC's recalcitrance in their response in the face of the court order is actually breathtaking. So Paul Graywall posted, a few minutes ago, the SEC filed its response to last week's Third Circuit. You can read it for yourself. Here's his take. They repeat the fallacy that they haven't made any decision on new crypto rules. They refuse to commit to any deadline despite the court's explicit order. They instead anticipate making a recommendation in 120 days. And most importantly, they ignore the clear statements of the chair that confirm they have no intent to issue new rules and instead conflate the evidence of a decision those statements provide with an argument that the statements are themselves a decision. So you notice, courts don't usually like it when you defy explicit orders, and when they ask you to give them a deadline or answer some question like that, they don't want a recommendation from you. They're the court. They're not asking for recommendations generally or anticipation. They generally want an actual date when they ask for a date. So if we get into the actual response here, you can kind of tell the tone of their response just from these little bits. So they were asked whether the SEC, they were ordered to answer, to address at least, whether the SEC has now decided to deny Coinbase's petition for rulemaking because they filed a case, a complaint, an enforcement action against Coinbase. They say the commission has not decided what action to take on Coinbase's rulemaking petition. The court's order refers to commission enforcement actions and statements by the commission chair, but neither demonstrated a decision to deny Coinbase's rulemaking petition, much less a commission denial of that petition. I don't know if it's going to go over well when you tell the court what its own references in its own orders actually demonstrate. I don't think the court wants to hear from you what its own orders, what some reference in its own orders demonstrate. I think the court already has a pretty good idea what it thinks those references demonstrate. Moving on, there's more. We get to stuff like this. So you remember that last part. How much additional time? So I guess like the second to last part, how much additional time the SEC requires to decide whether to grant or to deny that petition. So they asked, how much time do you need? They want an actual number of days, a date in the future, some actual period of time. The SEC responds, there is no basis for subjecting the commission's discretionary rulemaking agenda to a specific timeline. None is mandated by statute or regulation, and Coinbase's rulemaking petition has been pending for a relatively short time by any measure. So the court says, hey, you need to address how much additional time you require. This is a court order. This goes beyond statutes and other regulations that might be binding on the SEC. The court is giving you an order in the context of this case, and of course, the SEC comes back. Actually, there is no basis for you to make such an order. And granted, the court did say you must address this question. And I guess they are addressing the question here. But when you look at the tone of this entire response, it's kind of like a very entitled friend or child. It's like they're constantly borrowing your car and bringing it back to you on empty with no fuel in the tank. And you're like, hey, could you not, if you're going to borrow the car, could you not return it to me with no fuel in it? And they're like, I don't think you understand. My needs are extremely important and I don't have time to replenish your fuel when I borrow your car. And they're like completely aghast. You would even imply that they need to, do things like, strictly comply with court orders. It's like, there's nothing in here. There's nothing in this entire response that, kind of like gives any kind of indication that they're, really trying to comply with the court's orders. Granted, the court just said they needed to address each of the questions, so I guess they are addressing each of the questions. But man, I don't think this is going to ingratiate the SEC with that particular judge. So it'd be very interesting to see how the judge comes back once they've had some time to kind of digest this particular response from the SEC. I hope you're having a great week, and I'll talk to you tomorrow.